So friends, let's now move on to understand the doctrine of unconscionability. At this point of time, we must understand that when we compare the Indian contract law jurisprudence with the UK contract law, or what we call as the common law contract law, you will notice that in common law, the concept of unconscionability in contracts is a very important element to vitiate a contract and hold it as voidable. Now, unconscionability is also a kind of a factor underground under Indian law, precisely if one would want to refer to section 16(3) of the Indian Contract Act, 16th, that is 16, subclause 3 of the Indian Contract Act. Unconscionability is a matter of intervention for the courts. And hence, at this point of time, we will have to probably understand what is this unconscionable bargain or unconscionable term in a contract. Now, the term unconscionable means something that is not fair under societal terms and conditions or under social norms of a given society. Unconscionable, unacceptable, something that shakes the consciousness of a given society. And to that extent, probably the contract needs to be set aside because it is not acceptable as per the standards set in a given society. So there is no kind of an objective test for unconscionability, precisely so. But unconscionability can be understood quite best with a modern type of contract, and that type of contract is called the standard form of contract. Friends, to understand standard form, I think one will have to look at modern industrial revolution that has taken place, where you have, say, a market condition where there is one maker and there are so many consumers. Let's take one instance of what is this modern day industrial revolution market. It could be, say, McDonald's, which is supplying burgers or food retail, making the same in different cities, different jurisdictions and countries and continents, and serving large number of consumers. So this kind of large quantity of production or manufacturing or even services for that matter did contribute to what we call as the standard form of contract, which means that McDonald's is expected to draw a contract which is uniform to most jurisdictions, unless there is a law that specifies that there requires to be a change of the contractual terms and conditions. McDonald's would prefer that if it's selling burgers in the US and in India, the terms and conditions of the sale of the burger should be uniform. It should be standardized. That is what standard form means. Standardization of terms and conditions of the contract. Standard form of contract can also be understood best probably through what we would call as insurance contracts. Now, insurance contracts, take the example of Life Insurance Corporation of India. They would come up with a standard form for a particular policy, say Jeevan Anand policy. It's a life insurance policy, right? Now, what they will do is they will float this policy, and the terms and conditions of the policy, it will be prepared well in advance, and it is going to be standardized for all consumers who would be interested to take a life insurance with LIC, especially the Jeevan Anand policy, right? So it is one contract for multiple players. Right? That's what standard form of contract actually means. Now, standardization has a lot of advantages. One should understand this, that it saves time. Yes, see, if you are making separate contracts for each of these life insurance consumers, you'll be spending that much time in making contracts, right? So it saves time, right? That's the first precise advantage of standard form of contract. Second, it saves cost. Of course, you can't keep printing out documents, spending time, having, say, 1,000 executives trying to sit to negotiate, bargain with the consumers, then redraft. So it saves time and cost to a larger extent. And most importantly, I think it brings uniformity to a company like a Life Insurance Corporation of India. They very clearly know what are the terms and conditions of the contract. It's not like based on cities, it changes, based on the income of the person, it changes, based on the age of the person, it changes. So the companies have a peace of mind. They clearly know what are the terms and conditions. They can draw it pretty well, and they can defend it if required, right? So I think standardization in contracts is a way forward. I think even in business contracts, we notice this, that to a larger extent they go in for standardization because it has huge number of advantages to businesses, especially in terms of uniformity, consistency, saving of cost and cost time. Right. So, is it good to have standard form of contract? I would say it is inevitable. Right. So the good and the bad has to be tested probably in this session. But I think that's how standard form of contract do necessarily apply too. I think automobile manufacturers adopt standard form of contract. Service industry like hospitals also adopt a standard form of contract. What is that standard form in hospitals? See, there are probably 100 patients getting admitted to a hospital every day, right? Now, the hospital has to have a standard form for the admission of these patients in the OPD, right? At least in the outpatient department or in the inpatient department. That's the basic standard form of contract that hospitals will draw and ask patients to agree upon. Of course, based on your surgery, based on the procedure, there can be a special contract or a special form that could be made to sign. But at that point of time, in case that is required, say the cardiology department may have its own standard template. The gastroenterology department will have its own template, but that's in terms of specialization of surgery, treatment, process, or procedure that may be required. But basically, at the time of admission, probably the hospitals will have a uniform, standardized contract in terms of a form that has to be filled by the patient or the attendant before which they can actually start treating the patient. So this are some of the examples of standard form contract in different industries, both in the product and in the service sector. Let's not forget that standard form of contract does exist even in government goods and services. Yes, when government is probably giving you electricity, right, it is also a contract that the government is doing it. It's a service. It could be a business of that character. Now, just imagine if there is an electricity distribution company. Can they actually negotiate and bargain and make separate contracts for each of the consumers? No, not possible. So the electricity distribution company is going to adopt a standard form of contract. Now, let me tell you one essential condition of such a contract. They may say, look, if you don't pay your electricity bill in the consecutive 3 months that you fail to pay your electricity bill, then in those cases, the electricity distribution company will cut your electricity supply. It's a standard term, right? This is advantageous to the government. You know why? Because whenever government does any kind of an action towards the citizens, either through their state actions or through contractual actions, there is always this allegation that there is discrimination. Right? There's an unfair treatment. Standardization is a great form of challenging those matters of unfair treatment or discrimination. You know why? Because it simply would say that, look, for everyone, the rule is the same. Right? The contract is the same. The terms and conditions are the same. So I think standardization does help. And it's a great defense against discrimination or challenges or allegations of discrimination in government services, including that of banks, which are majorly public sector banks. They are held by the government. So they have standard forms to their constituents. They say, look, this is our prepayment charges. This is our processing fee. These are all standard. So for you also it is 3,000. For others, someone else also is 3,000. So we don't change the processing fee and the terms and conditions of the contract. So advantages of standard form are very much there. It's a privileged practice. And I think, in most places wherever you can standardize these forms and contractual terms and conditions, I think it is very, very useful for the businesses. However, the real issue now is, yes, there are advantages, but are there challenges? So the first and the basic challenge is whether it is a standard form or not. More than often, because the seller, the manufacturer, the producer, the service provider, it could be government or any other person like McDonald's or any other entity. It could be, say, a coaching institute. It could be a service company like, that we have in terms of who is giving you what service. There are so many service agencies, right? They may give you insurance, they may give you other kinds of services like billing and so on and so forth. It could be electronic services like a website, say Gmail or Facebook or social media or any. They're giving you a lot of these services. Now, many of the time, Gmail cannot have differential terms and conditions to its users, so they have to standardize. Great. Now, having understood that, I think it's important to understand that quickly, there is always the difference between fair terms and unfair terms. Right? This is quite subjective to the kind of contract and to the kind of clause that one will have to flag and say, this is fair and this is unfair. But very often they not look the power of making a contract, and especially the power of making a standard form of contract. You know this power. You are the contract draftsman at McDonald's. You know this contract will go around the world and every consumer will have to agree to the same. Right? And you know that as you have been employed by McDonald's, you ought to protect the interest of your client, your employer. You have to be loyal and faithful. Obviously, what will you do? You will create terms and conditions that are conducive, that are favorable, that are advantageous to your company, to your client. Right? And hence the power of that contract making is subject to some kind of a scrutiny, and very often than not, we say power corrupts. Yeah, absolute power corrupts absolutely. And hence this power of making the contract can actually corrupt your mind to actually add unfair terms in contracts. So tomorrow if a consumer sues, you should be able to say, no, we are not liable. Right? So what happened in the 1970s and the 1980s was, especially if you look at the UK law, because the UK did decide to bring in special legislation called the UK Unfair Terms in Contracts Act in 1977 itself. Yes, they realized that the market is getting exploitative, contracts are having a lot of unfair terms, consumers are being exploited, we need to protect it. So they did not only look at consumer protection, but they said, let's look at unfair terms in a broader context, because it's not only in consumer contracts you have unfair terms, you need to look at it in a very broader perspective, right? So there you will notice that a lot of developments did happen. And the courts, interestingly, started intervening in standard forms of contract, and they started judging what is a fair and what is an unfair term. Because remember, friends, if certain kinds of terms in these contracts are totally shocking the consciousness of the society, what can shock the consciousness? What can be a term that is unconscionable? Let me give you an instance or an example. Let's assume that one of you goes today and gives your cloth, right, to a laundry person. Dry cleaner. Now, you expect the dry cleaner to give you a receipt, right? Where is the terms and conditions of the contract? You have the receipt, but what are the terms and conditions? No, you may be saying, sir, why do I need a term and condition? You need a term and condition because tomorrow, if he does not service the cloth well, he does not dry clean it well, can you sue him? Can he then for that deficient service demand the actual cost? So there can be a dispute that arises, right? See, contract is required as a risk assessment document, right? It is to analyze in case something happens. It's like, anticipation. We hope nothing will happen. We hope the dry cleaner will do a good job. But in extreme cases, he does not do it. Like, for example, you go to a hotel, right? You expect good food to be served to you. But at times, you will find that good food is not served. Maybe the food is contaminated. There is some kind of external elements like you will find a hair or an insect. You may find, and you will probably raise an objection to the kind and quality of food or the purity of food that is being supplied to you. So I think to a larger extent, consumers or the buyer or any other party in a contract may feel aggrieved by the product or by the service. And there you would notice is the time when you will go through the terms and conditions of the contract. Right? Now, imagine a laundry person. He takes your cloth and damages your cloth when he returns it back. It's an expensive sari or a Kanchivaram sari, and he damages it. Then what do? You will probably raise a hue and cry. You will probably fight with him. But apart from that, the illegal part, let's talk about the legal part. What else can we do in that? Right? So you will notice that it is important at this point of time to understand that the one who can draw the receipt can also draw the contract terms and conditions, right? And please note, the early times the judges did evolve a very interesting principle. They said, and this is the case of the Thornton versus Shoe Lane Parking Limited, where the courts did make a distinction between a contract and a receipt. Yeah, they did make that. They said contract has every term and condition, and both the parties should agree for that contract. A receipt is just, a kind of a acknowledgement that the goods have been delivered. So receipt, the court said, is the evidence of the contract, but not necessarily the contract itself. Yeah, it's evidence. Because we say the contracts can either be express or implied. So when I give the goods and I expect him to do the dry cleaner, it's an implied contract. Now, what is the evidence of that implied contract? Maybe the receipt. That's it. But the receipt itself is not contract. Right? You have to make the distinction. But interestingly, friends, you will notice that in the receipt, and this was quite in early days, the courts said, look, if you are giving just the receipt and at the back of the receipt, you have the terms and conditions written on the backside. It is your duty as the seller or the service provider to say PTO on the first page. What does PTO stand for? Please turn over for terms and conditions. Right? So the court slowly started saying, look, you did not bring into the notice where the terms and conditions is. Wasn't your duty to, in the receipt, tell that, look, that for terms and conditions, please refer here. Yes, that is your obligation because, you have standardized these contracts. The buyer does not know whether this is a receipt or a contract. You have the contract written somewhere else. You should have brought it to the notice of the consumer. So please turn over was one of the judgments that was given by the courts. The second judgment that was given by the court was very fascinating. They said, look, when you turn over in the backside, or why backside, just take an insurance policy for that matter. The standardized terms and conditions are actually printed on a sheet of paper in very small, fine words. Right? A person like me or someone who needs spectacles probably cannot even read it, or there are so many terms and conditions that you simply don't have the patience to read or appreciate or understand it. Right? So the courts also intervened and said, look, fine, you printed it finely because you want to save paper, you want every term and condition to come just in one sheet of paper because that is the receipt that you're giving, so you're cramping a lot of things and a lot of information and lot of terms and conditions. Fine, do it. But then, please note, highlight, bold the exclusionary terms and conditions, or those terms and conditions that may affect adversely the rights of the buyer. So you have to bold it, or such terms and conditions that may be problematic, objectionable, that affects the interest of the buyer, you please put it in red. So that the buyer, even if he does not read the rest of the terms and conditions because they're so small, they're so cramped, he should at least be able to find out, yes, this is the problem, this is the term and condition that I should be aware of. So those duties slowly started being brought by the courts in standard forms of contract. They said, it is your duty to bring all of these together. Interestingly, when it came to electronic contracts, very interestingly, in a case of Hotmail, see what happens with, say, opening an email account, right? You have to agree to the terms and conditions before you open to the email account, right? Can you have an email account open without agreeing to the terms and conditions? No, because you will notice that a dialog box opens, right? It's a box that opens and says, please agree. So you have to scroll down the dialog box. There are two buttons, I agree, I do not agree. We mostly click the I agree button. And only when we click the I agree button, your Gmail account opens or any software gets uploaded or the apps get uploaded. And interestingly, the apps that are uploaded or to which we subscribe now ask special permission. Can we access your contacts? Can we access your Gmail account? So this is how probably they have to highlight certain factors which may be very, very important. After taking our consent, they actually give us those services. And they are all standardized. So when MS Office gets uploaded into, say, a laptop like this, this is standardized terms and conditions. And unless I agree to it, the software is not going to give me the services, right? Which clearly brings us to this fact that even in electronic contract, in online contracts, everything is standardized today. Say Flipkart, Amazon, right? Or any other website that is giving you those services as a market, player. They're saying we are a marketplace. Buyers and sellers come and meet. But yes, you are logging into Amazon, and that is where the contract is being made. So every term and conditions of Amazon delivery of services or making the buyer and the seller meet is based on standard terms and conditions, right? So this is where the whole issue about fine, this is a practice, it has advantages. However, how do we start evaluating whether the term is a fair term, whether it's an acceptable term, or whether on the grounds of unconscionability, the courts can intervene and actually set aside the contract entirely or set aside just that term that the court finds it as unreasonable. Don't forget the fact that if you read the Indian Contract Act, voidability are of two categories. First, you can void or hold the contract voidable entirely, right? Because the unfair term is so core and essential that the contract in its entirety has to be held to be voidable. However, if you apply the doctrine of severability, right? So contracts today are quite complex. They're quite, large in the context of what it is. In those contexts, please note, if you apply the doctrine of severability, there is a possibility that the courts may read down. This is called the reading down kind of an approach of the court. They may say the objectionable clause is to be taken out of the contract because it's unfair, it's unconscionable. But the rest of the terms and conditions may be fine. Or the courts may come to this conclusion that in that clause, one word is objectionable and unfair. We need to probably read this contract, deleting that word. So these are all kinds of possibilities that the courts may adopt. Now, for that, interestingly, you may also look at a very interesting principle called the blue pencil rule. Yeah, we will discuss a little bit more about that when we talk about other kinds of contracts, especially under Section 27. It's like an editor's blue pencil, right? So judges are like editors. They will read the contract. They will then underline, oh, this is the unfair clause. In the unfair clause, this is the unfair word. And hence, let us strike that unfair word out. And the rest of the contract can probably go through if the judges feel that the rest is fine to go through. So unconscionability, friends, is a very, very subjective affair. Unconscionability, say in the 1970s, need not be unconscionable today. Unconscionability, say in India, need not be unconscionable. So it is based on market conditions. So it is something that invokes the idea of the judge in terms of the moral consciousness and the legal application of mind in contracts, right? That is where unfair terms in contract becomes a very, very important and a critical factor. So taking this forward and understanding unfair terms in contracts, we will have to appreciate that in India as well, there has been a long-standing, requirement to moderate contracts so that it is one, not unconscionable to the societal values and societal system. Second is also with the requirement that we all know that contracts are made for profiteering, right? It's a commercial transaction. So there's nothing wrong about profiteering from contracts. There is nothing wrong about, looking at making best market value in a contract. However, I think every society understands that any kind of a legal system cannot encourage unjust enrichment. And contracts should not facilitate any such practices of unjust enrichment. And hence, unfair terms in contract has been for a very long period of time subject to judicial intervention and judicial scrutiny, and a lot of principles and doctrines have been put across from time to time, not only in India but also in the West. However, you will notice that in India, a Law Commission report, the name of the report is called the 199th Law Commission report, did study unfair terms in contracts. And they divided unfair terms in that report into two very important characteristics. One is called substantive unfairness, the other is called procedural unfairness. And I think the Law Commission report is, some kind of a standard for evaluation. Though Law Commission report should have resulted in an amendment to the Indian Contract Act or in terms of a separate legislation like one in the UK, the government probably did not take that very seriously. But you will notice that right now with the Consumer Protection Act of 2019, to some extent unfair terms in contracts and unfair trade both are covered. Right? I'll come to that in a little while in just trying to tell you what that consumer protection law says. But as of now, you will notice that two kinds of unfairness exist in making contracts. The first one is, friends, what we call and what the Law Commission says is the procedural unfairness. Friends, please note, procedural unfairness is unfairness at the time when the contract is trying to be made. And that is when consent becomes very relevant and important. What can be this procedural unfairness? Friends, you will notice that in standard forms, we have a concept which is known as take it or leave it contract. Yes, which means an insurance company or a hospital very clearly says, look, this is my contract, this is how it is, take it or leave it, right? You have to sign right now. For example, you go to the hospital, before even probably they start treating the patient, they say, please fill the form, right? Or please sign it over here. So that is a procedural unfairness. Procedural unfairness comes from the fact that one, the consumer, customer, or the client or the contractor does not get time to read the contract properly before he agrees to the same, right? Second, procedural unfairness could also mean that, look, there is no room for dissent, there is no room for denial, there is no room to say, I will not agree to the contract. That is procedural unfairness. And in many circumstances, this procedural unfairness does exist. For example, let's assume that you are taking a car to a shopping mall, right? Now, what happens is, as soon as you enter the shopping mall into the area where it is parking, there is a place where you have to actually take the ticket for parking. You press the button, it's an automated kind of a system. You take the receipt and you go inside and park the car. Now, the procedural unfairness is here, friends, that look, while you are entering the shopping mall, just that you have pressed that button and the ticket comes out, the contract is already being made without you being told the terms and conditions or where the terms and conditions exist. So where is the terms and conditions of the shopping mall, right? Usually they will say parking at owner's risk, right? Is that a adequate term and condition, or is it an unfair term and condition? And you will notice that in the show lane parking limited, very often than not, there are these kinds of procedural unfairness where the customer or the individual does not have a choice about who the contract is being made to. So if I'm going to a shopping mall, I have to park within the shopping mall. Now, the shopping mall owner himself may provide the terms and conditions of parking, or he may outsource it to some agency that is managing the parking area, who thereby or then would actually lay down the terms and conditions of that parking area, right? Now, suppose in the shoe lane parking case, you go, you shop, and you come back and you see your car is damaged. Will the shopping mall owner take responsibility and liability? Obviously not. If I have the power of making the contract, I will, as far as possible, either exclude my liability or shrink my liability, or what we would want to call as limit my liability, right? So the procedural unfairness is very much an important part of how the contract is being made, how the consent is being got, whether choice is given to the consumers. For example, let's take hospital contracts. Now, when you go to a hospital, do the hospital or should the hospital give you a choice of a second opinion? If they don't give you, I think this is procedurally unfair, right? Can you take the patient out and get the surgery done in some other place if you wish to do that? If they don't give you a choice, I think that is going to be procedurally unfair. Similarly, with government contracts. Interestingly, in many cases of government contracting, I come across a lot of procedural unfairness in the steps in which the contract is being made, right? Or how the contract is executed. Inevitably, very often than not, the government shows a higher position of dominance and bargain in such contracts. Procedurally, please note, especially when you are making government contracting or government actions, you will notice that the courts have insisted that fairness is an important rule, right? Fairness should not only be done, but it should seem to have been done, especially in those documentations in which government contracting is being done, right? For example, choosing the L1. You force the L1 to start the work sometimes without even giving the letter of intent. Yes, it is a practice in many organizations. So would that be procedurally unfair? Interestingly, in many cases, the contractor has completed the job, yet the agreement to the contract was not issued. Is that procedurally unfair? Maybe these are some thoughts that we should all evaluate in terms of what procedural fairness of choice, consumer choice, customer choice, contractual choice must be provided. And I think that goes a long way in establishing a fair contract system in any country. The second aspect of substantive unfairness is also critical and important. Why? Because substantive unfairness, friends, is about the term in the contract, which is the substance of the contract, being held to be unfair, right? What is unfair? When any kind of term in a contract takes only one side or only favors one party, or gives the right of, say, termination only to one party without giving any rights to the other party, that can be considered as substantive unfairness, right? So unfair is a terminology which every society wants to judge. Unjust, every society wants to say. They want to have criteria, they want to have parameters, they want to say this is okay, this is not okay. The do's and the don'ts in the contracts have to be laid down. You cannot allow freedom of contract to such an extent that the ones who probably don't know about their rights feel exploited. The ones who do not know how to make a contract feel excluded from the fairness of the legal system. Though we say contract law is civil law, though we say contract law is private law, I think unfair terms in a contract actually are an important part of intervention. It shows the robustness of a given legal system. It shows the growth in a given society. Economy and market condition will only strive when fairness is not only practiced by government agencies through government actions, but also through government contracts and even private contracts, right? Now, substantive unfair terms in contract, friends, are basically of two very interesting characters. First, very often than not, you have what we know as exclusion of liability clause. This is usually the the main core crux of the unfair term in contract. Let's take an airline for the matter, say Indigo airline or some other airline that is giving so many passenger services. They're flying from destinations for A to B. Now, Indigo has to have a standard form of contract to all its passengers, right? Because of the just sheer number of services that it is providing to so many people. Standardization helps for Indigo. Now, what will Indigo probably say in case it talks about exclusion of liability? Please note, it may say something like this. It may say, look, we will not, refund, and this is the controversy of the refund clauses, to be honest. Moving on and going to understanding exclusionary clauses in standard forms of contract, one must understand that contracts try to either diminish the liability. For example, we have seen that the interlink between tort law and contract law is such that tort law is basically the law on civil wrongs, and there can be a wrong of negligence, and you notice, suppose a hospital commits medical negligence, then under tort law the hospital is liable to compensate for the medical negligence to the patient and to the consumer. Now, if this is what one has seen in tort law, the movement to contract law, you will notice that it is this same hospitals who will now draft a standard form of contract, who will draft a form in which they can do a couple of things. One, they can exclude their liability. A clause could be such which says that, look, the hospital shall owe no responsibility or liability for any death that may cause due to an act or incident or accident within the hospital. These are called exclusion of liability clauses. Now, the point is, when there is a public element of liability, which is the negligence law, which is the tort law, can contracts waive or diminish that liability? Right? This is a kind of a public policy debate. Now, at one side, when you talk about exclusion of liability clause, on the other side, you look at limitation of liability. Now, interestingly, friends, the advantage of contracts over tort, is that in tort, because there is an evidence of the relationship between the hospital and the patient, it's an evidentiary document. The evidence can lead the judge to decide the quantum of liability, right? Because in tort law, as we know, tort law is basically judgment law. It's entirely the discretion of the judges. Judges will decide the quantum of liability. Judges will decide the principle of liability. Judges will actually decide if there is a liability in the first place or not. There is no statute that guides the judges. Yes, there are some modern statutes like Consumer Protection Act which have codified tort law, but tort law is generally entirely not codified. It's judge-made. It's just discretion. Now, what does contract do? Friends, the same relationship, when you put it in a contract, then the contract determines the rights and liabilities of the parties. There will be a document that the judge will have to interpret, use, and this will limit the discretion of the judge. And hence, is it possible in contract and in standard form of contracts to have limitation of liability? I think if you go by the judicial verdicts on what we call as the LOL clause. It's not laugh out loud, but it is limitation of liability clause. You will notice that the judges have said, while exclusion of liability is unacceptable, it is against public policy. Because remember, when there is some kind of a negligence, when there is some kind of a public duty of care, you cannot exclude your liability in contracts. So contracts cannot be misused or abused to exclude your liability under tort law. That's not acceptable at all. However, can you think about limiting your liability? I think the judge's answer here is an interesting one. What the courts and the judges have said across jurisdiction, and please note this is not only pertaining to India, it can pertain to UK or US. The judges have said limitation of liability is fine, provided the quantum of that limitation is reasonable and acceptable. So the test of reasonability is the test of fairness here, right? While the parties have the freedom of contract, while standard form of contract can look at limitation of liability, they can actually have a certainty about the extent of the liability. Because remember, as I told you in standard form of contract, the number of contract, the sheer number of contract is the problem and the challenge. Now, in all of these sheer numbers of contract, if every case the judge has to decide, you can imagine the kind of uncertainty. How do I prepare for that extent of liability? Right? Say 100 patients sue a hospital for negligence. How do I prepare? What should be my liability structure? Right? How do I assess my risk? So limitation of liability can cause that kind of an advantage to these companies, to these hospitals in standard form of contract, provided what is the rule is that they ought to be reasonable. Right? They ought to be fair. Right? Fairness rule is a very important rule when it comes to liability, right? Let's assume product liability. Now, let's assume that you have thought of buying an MS Office. Now, the MS Office contract says that we will not be liable if the software does not work. Is it acceptable? Will it not shock the consciousness of a given society that, look, Microsoft is a very big company. They ought to take responsibility and liability for their product. Will you allow Microsoft to exclude its liability? Will it be acceptable to the consciousness of any legal system? I don't think so. And hence, exclusion of liability is considered unconscionable, whereas limitation of liability can be conscionable provided it is reasonable. And hence, please note, limitation of liability is also to be viewed from the kind and categories of contract that I've already said. For example, I said B2B contracts. Limitation of liability is very much acceptable because it's a fair bargain between two parties. B2C, the test of reasonableness. B2G, that is business to government contracts, I think limitation of liability works pretty well because that is what will make the performance of the contract all that more interesting and viable. Similarly, friends, there are other challenging clauses that are there in standard form. Like I told you in the past, the refund clause. Right? Now, let's take an airline, or let us take a bus service provider, or any other transport service provider. Very often than not, if they are unable to complete the journey due to A, B, and C factors. Now, for example, the flights are cancelled. Right? Why? Because there is a technical problem. The flight is undergoing some repair. There is a safety issue, or the flight gets delayed. Now, all of these, you will notice that the companies that are offering these flights have to have certainty. They have to anticipate that these things will happen. A bus will break down, a flight will get delayed, a flight will be cancelled. These are normal things that they have to be anticipating in their business. And hence, anything that is going to be anticipated as a part of their business, they have to have a contractual clause regarding the same. It should be certain. Their ground level officers or people or employees must know how to deal and what to give and what to not to give. For example, my or your own experience would be if the flight is delayed beyond 2 hours, if you're stationed at the airport, do the airlines have to give you food? Maybe the clause says we will give you food or we will not give you food. If there is a delay, now please note you have connecting flights, and because of this delay you lose the connecting flight. Will an airline actually compensate you for the loss of the connecting flight? So I think all of these characters are something that you can anticipate in passenger aviation business. These airlines pretty know well what to be done and what not to be done, and hence they will have a contractual clause which may either exclude the refund or may give you a partial refund. Right? Excluding refund, I think, is highly unreasonable. But probably when you talk about a partial refund, because that is something that you will say may be fair considering the already incurred cost of these companies probably to arrange that particular situation. Similarly, friends, you can extend it to a cricket match. Suppose you are a fan who want to go and see a cricket match. The cricket matches can be cancelled due to rain, right? Sometimes it could be cancelled due to some other factors. Now, if the match is cancelled, do you have a right of refund? Right? When, say, the Indian Premier League is organizing IPL matches, there are so many funds. So you have to have a standardized contract, standardized terms and conditions. So you will notice that IPL will also have to pass the test of fairness. Fans have to get their due, right? These cannot, you don't expect BCCI or IPL to profiteer from consumer interest and contracts. And hence, that element of fairness in terms and conditions of the contract, I think, is very, very critical and very important for all of us to appreciate and understand. And I think the judges and the courts go a very long way in trying to moderate, temper down, balance the interest of all the parties in the system, because they do not want to entertain unconscionable terms and conditions. So what is conscionable is what is acceptable. What is unconscionable are something that the courts have a duty to strike down, read down, exclude it, have a doctrine of severability, and try to come to this conclusion that such kinds of contracts are definitely what a legal system will not encourage. Also, friends, you will notice that one of the fundamental principles in standard form of contract is the concept of fundamental breach. What does this say? It says simply like this. Your contract may say anything, right? Your contract may say, we only take this liability, we don't take that liability, we do this, we don't do this. However, the concept of fundamental breach very clearly means this, and please note, this is there in common law, the doctrine of fundamental breach. It is also part of international contract law. For example, if you ask me what is international contract law, there is a United Nations law on international sale of goods. It's a 1999 Vienna Convention on International Sale of Goods. Please note it down. It's an international law. India has not been a party to this international convention, so it's not necessarily that it's binding in India. However, the principle of what is the doctrine of fundamental breach is also there in this convention, which clearly says that irrespective of the terms and conditions, if a contract has committed a fundamental core breach, then the contract shall be repudiated, right? So in a standard form, fundamental breach, what is fundamental breach, friends? I take a bus from, say, Bangalore to Mysore, right? The bus never reaches Mysore at all, right? And it does not start from Bangalore. It's a fundamental breach. You can't have contracts which actually evade your liability in those circumstances. There is no forgiveness that the law can give and say, oh, the terms and conditions of the contract will prevail and the consumers or the other party will not get. So fundamental breach means the basic obligation has not been completed, has been broken, has been violated, and that's the core of the contract. Now, for example, insurance contract. What are they supposed to do? They are supposed to cover your health, they are supposed to cover your life. If that itself, they say, look, that is based on A, B, and C condition, right? And unless those conditions. So I think, the doctrine of fundamental breach gives the court a very strong weapon to actually intervene in contracts, and it gives the courts the fact that if the core of the contract is violated, no standard form of contracts will be considered as fair, right? Irrespective of the fairness or irrespective of the unfairness of the contract, fundamental breach very clearly gives the rights of the parties to repudiate the contract, which means I can get my entire amount back and I can also claim damages. That's what is the concept of fundamental breach. Don't forget, fundamental breach is also about safety. For example, I buy an iron box. Okay, now the iron box is supposed to iron, right? It has to, work. It should be functional in that sense. Now I take home, it doesn't function. Rather, it gives me some shock while I was operating the same. So it affects the safety. That is the fundamental breach. What it is supposed to do, it does not. Additionally, it's a safety problem for me. Your contract may say, look, we don't take the iron box back. It may say so, right? We have no return policy. It may say so. We don't give refund. It may say so. The court will say, sorry, none of these matters. What you have sold is not fit for sale at all. That is a fundamental breach. And hence, In those cases, the contracts, the terms and conditions does not matter at all. They will be thrown to the dustbin by the courts of law, and you will definitely have the right to repudiate the contract. Finally, friends, coming to the rule of contra preferentum. This is the most important rule I think one should appreciate, understand, analyze, evaluate when it comes to standard forms of contract. Contra preferentum means let the drafter of the contract justify his deed. Right? Drafter, justify your deed. That is what contra preferentum means. So, who is the drafter? Friends, LIC, Life Insurance Corporation of India, is the drafter. Indigo Airline is going to be the drafter. The person who produces and manufactures the IM box is the drafter. They make the contract. McDonald's is the drafter. They make the contract. They make the contract for the entire world, for all the customers there. So the contract is drafted by them. If they have drafted it, they ought to justify their contract as being fair. So contra preferentum is a rule that actually puts the burden of proof in a court of law on the drafter of a contract to come to the court, justify the court that the contract is conscionable. It is valid, it is fair, and it does not violate the basic principles of the systems of the legal system. It is something that they have to discharge. As a consumer, as a person on the other side of the contract, I just have to probably say that, look, my rights have been infringed. Let the terms of the contract be justified by the other party. He has to come to, so it can be the hospital. So they have drafted the contract. The patient has just signed, right? It's a take it or leave it contract. We say it is boilerplate contract sometimes. Contracts of addition. That is the name that is given to standard form. Boilerplate contract. What does that mean? Friends, it's boilerplate means, on the plate, on the iron plate, which is a tough plate, the terms and conditions are printed, and then the plate simply keeps falling on every other contract of paper. Nothing changes. That's what a boilerplate contract is. And when there are so many such names given to standard form, the rule of contra preferentum puts the burden of obligation on the drafter, on the other side, on the other party. They have to justify their deed. They have to come to the court. And hence, that very clearly is a very interesting, important element that can be brought into the litigation of standard form, in which I think very clearly, if you are unable to satisfy the court that your contract is fair, then the court will definitely strike down and hold your contract to be unconscionable, something that is not acceptable as per the social, moral, and legal norms of a given society. Judges have a right to intervene in the freedom of contract so as to protect the exploited party. And you will notice such kind of rules can also apply in government contracts in cases where there is standard form used by the government. As I told you earlier, government does give you a lot of services. It could be Indian Oil. That is also giving you certain kind of services. It could be LPG, it could be electricity, it could be water. All of these kinds of consumer-related government services and products are under the standard form of contract rule. So I think the rule of contra preferentum is actually the icing on the cake, for the simple reason is that now you clearly know that the courts not only read the contract and evaluate it, but they also protect the innocent party from proving or bringing the evidence or having the burden to say that it is an unfair contract. Let the other party, who is in a better position, who is in a more dominant position, who is the one who has drafted the contract, proving the court of law that yes, this is the contract that is reasonable, acceptable, and please ensure that it is enforceable. If they fail to discharge the burden, the court is going to come to the conclusion that this contract is an invalid, voidable contract and it has to be set aside.